Let us viva! Let us long live! Ruto must go! Ruto must
John Mulingwa, Nzau alias Garang, Amiani alias Generali, Francis Mwangi alias Chebukati.
My name is Owiti. I appear together with my colleagues and we are directed by the Director of Public Prosecutions to prosecute the application dated 29th June 2025 as correctly noted by my learned senior. And without attempting to water down the good words he has mentioned in the introduction, we believe that we go first. Our application is based on Article 49(1)(g) and (h) of the Constitution, Section 123 and Section 123A, that is capital A of the Criminal Procedure Code, the Judiciary Bail and Bond Policy Guidelines, and the trillion of judicial authorities from the superior courts on the question of custodial orders and bond in the country. Our prayer is on the face of the notice of motion, and more particularly prayers B and C. Prayer B being that each of the respondents, or rather that there be an order of detention continuing, in the words of Article 49(1)(g), an order of detention continuing against each of the respondents for a period of 21 days to enable completion of investigations that the Directorate of Criminal Investigation informs us are already instituted and ongoing. In our recommendations as to the police stations, should the court agree with our prayer, are also listed in prayer B as 1, 2, and 3. And the last substantive order is that a number of electronic gadgets, including mobile phones, which were seized from the respondents, be subjected to forensic examination pursuant to an order of this court that we are seeking in that prayer number C. The application is supported by the affidavit of Inspector of Police George Karanja, present before court. And in a sense, as we've highlighted, fundamentally a release of each of the respondents is, in the view of the investigators, a threat to the completion of the pending investigations. There are also accomplices, or rather possible accomplices, so that the release of the respondents would interfere with the possibility of arraignment. But my learned senior, Ms. Veriano, will take the court through the affidavit. In summary, therefore, we submit to court that indeed, as indicated by learned senior Dr. Haminwa, the respondents were arrested on Friday and have been availed to court at the nearest possible time. In the words of Article 49, that they be brought within 24 hours or the next possible time, which is Monday. It is also correct that each of the respondents was arrested without a warrant. But Your Honor, in response to that, we will be pointing the court to page 2 of the application, just overleaf, the types of offenses presented as the possible offenses under investigations include arson, stealing, housebreaking, and malicious damage, all of which offenses are cognate offenses and which do not require warrants. Each of them is a felony and which do not require warrants of arrest before a respondent is arrested. We will not take lightly the mention of the manhandling. We regret if that were to have happened, and we will urge that the defense will take that up, make sufficient reports so that that can also be separately investigated, so that anyone who is culpable may equally face the law. At the conclusion of the submissions of my learned seniors, we urge you to find that the prosecution has established sufficient basis, in other words, appropriate justification for this court to order that each of the respondents is held further to enable us to complete our investigations. Your Honor, we will most likely respond to the authorities that we preempt, our colleagues will highlight, but I would like the court to have a look at the decision of Oscar Kipchumba Sudi, which is a locus classicus in this type of applications, and especially paragraph 24 thereof. I suspect my colleagues have it. And it sets up a two-test, or rather a two-tier test for establishing whether an application for what the Constitution calls detention continuing has been met. And one, that there are exceptional circumstances, as will be seen from the affidavit. The greatest of them being that during the constitutionally sanctioned demonstrations, there have been allegations of infiltrations by people who have come to be called goons, and that investigations have been instituted to determine who are the legitimate demonstrators and who are the goons. In a bid to establish that thin line, the investigators are asking for 21 days. And they suspect that the respondents may be part of one of those groups.
This maintains silence.
So that, Your Honor, it is also possible that...
Your Honor, may I say something?
Yes.
Because of the nature of the matter and the environment in which we are all acting, we have to be very careful with what words we use in the court.
Yeah, I don't take that as a threat, so I'll just proceed. We are telling court that we also believe that there's the possibility that at the conclusion of the 21 days or any other amount of days that the court will give, it is still possible that the respondents before you would be on the proper side, the legitimate side. And so that determination can only be made upon the conclusion of investigations. We are therefore asking you to give that investigations a column through which it can be concluded to establish whether the respondents before you are legitimate demonstrators or goons, on the other hand. In conclusion, we highlight that we believe the material before you, both on the application and the supporting affidavit, raise exceptional circumstances, and I agree with the senior that these are matters that the court can take judicial notice about, the situation and circumstances of the country by dint of Section 60 of the Evidence Act, and so that the circumstances before this court are themselves exceptional circumstances. And finally, that the manner or the circumstances leading to the arrest of the respondents indicate a link between the investigations and each of the respondents. And that dual issue of the link and the special circumstances is sufficient reason for you to issue us with the orders. I am privileged to appear before you for the very first time. I thank you.
Yes, Your Honor, I'm going to be relying on, just to add to the submissions made by my colleague, I'm going to be relying on the affidavit sworn on the 30th of June 2025 by one George Karanja, who is an inspector of the police. And Your Honor, because the court will have good time to actually go and look at all the facts that have been deposed in that affidavit, I will lay my emphasis on paragraph number 3. Your Honor, where the applicant is apprehensive that due to the ongoing investigations and the seriousness of those offenses, we have reason to believe that it is important for the said respondents to be held in custody to assist in the investigations and also to enable the investigation department to collect all the relevant evidence. Your Honor, I'll also lay emphasis on paragraph number 4, where one of the compelling reasons why we are saying that the suspects should remain in custody, that is the respondents, is that the respondents were arrested on the night of 27th June aboard a Mombasa-bound motor vehicle, registration number KCE 959X, and that, Your Honor, is when they were arrested. And we are making this application to support the fact that demonstrates there are flight risks. Because the moment these offenses were detected or were committed, the respondents were attempting to flee. Your Honor, I'm also going to lay emphasis on paragraph number 10, 11, and 12. 10 being that there was a notebook that was recovered, which notebook appears to outline the organizational plans, including mapping the specific areas, or rather the coordination that the respondents together with others were intending to undertake. So by holding them again, this will enable such investigations to complete. And then, Your Honor, the massive destruction of property, together with the unlawful entry into buildings, the looting of the business premises that was witnessed, the violent attacks on the police stations, caused widespread fear and compromised with not only public safety, but also national security. Your Honor, we will also be laying emphasis on paragraph number 15 and 17, where 15 talks about the complexity of the investigation, and therefore the detention will allow for proper and complete evidence collection without any interference or influence. Your Honor, it is also our humble submission, as the fact depend on paragraph number 22, that the respondents be detained at the following police stations, that is Motaika Police for the first respondent, Gigiri Police Station for the second respondent, and Capitol Hill Police Station for the third respondent. This, Your Honor, will allow seamless and proper flow of collection and evidence without any interference. With those few submissions, Your Honor, we reiterate that you grant us the application in terms of pair B and C, or any other order that this Honorable Court may deem fit. Thank you, Your Honor.
Thank you, Your Honor. My name is Itu. With your kind permission, can I just add the legal proponents to our application? Your Honor, in addition to the case law cited by my learned colleague, of which the court, Your Honor, to be guided by the case of Republic versus Dennis Itumbe, 2019 Kenya Law Reports. Your Honor, where the court held that the 24-hour rule is subject to lawful exception, where the prosecution, Your Honor, has provided a concrete affidavit detailing the progress of investigations. And Your Honor, the court held that that is permissible under section 96A of the criminal procedure.
So let's repeat the citation.
I'm saying, Your Honor, this is Republic versus Dennis Itumbe, 2019 Kenya Law Reports, Your Honor. We are submitting, Your Honor, that we have provided a concrete affidavit that extensively details, Your Honor, sufficient grounds as to why this court should allow our application subject to section 96A of the CPC. Your Honor, I would also humbly urge this court to be guided by the case of Kenneth Omondi Ochieng. Kenneth Omondi Ochieng versus Republic, 2019 Kenya Law Reports. Your Honor, where the court held, in summary, that extended detention is a valid prosecutorial tool where further investigations need to be conducted before the charging of any suspects in court, Your Honor. And the court went ahead and held that Article 49 does not prohibit the courts from granting reasonable extension upon being satisfied that the results advanced meet the threshold of necessity, Your Honor, meet the threshold of necessity and proportionality. That, Your Honor, when the court retires to go through our application and affidavit, will determine and see that indeed we have met the threshold of necessity and proportionality. And lastly, Your Honor, I would urge the court to be guided by the case of Republic versus Nzau. I have not gotten the last name, Your Honor. That is 2020, the Kenya Law Reports. I don't know, I'll get a full citation. We'll provide all this, Your Honor, to the court. And we urge you, Your Honor, that to allow the investigating agency to conduct proper investigations so that they can meet the threshold tests that is required, Your Honor, under the decision to charge guidelines before any charges can be presented. As my colleague said, Your Honor, it might either implicate or exonerate the suspects. So all we are asking for, Your Honor, is a chance to complete the investigation. This is so humble.